Hey guys, and welcome back to my channel. My name is Melissa Siegel. I'm a professor of migration studies, and this is a channel about all things migration. And today we are diving into the concept of safe third countries, a crucial yet complex idea within the world of asylum and refugee policies. I will explain this concept with the European and non-European contexts, as well as the challenges with this concept and how it is often misused. But to understand where we are today, it's important to first look at how this idea came about. The concept of safe third countries, or STCs, began taking shape in the 1970s and 1980s. Its original goal was to address the issue of so-called refugees in orbit, people who were stuck moving between countries, repeatedly denied asylum, and unable to find safety elsewhere. So, to fix this, the idea was introduced that refugees should seek asylum in the first safe country they arrived in, rather than continuing their journey to another destination. It first appeared in legal form in Switzerland in 1979 under the term country of first asylum, and then spread to other parts of Europe, particularly Scandinavia, in the mid-1980s. By the 1990s, more European countries began adopting this idea under the term host third country. Now, this idea of a safe country gained even more prominence in the European Union during the early 1990s. As the number of asylum seekers increased, EU member states started to worry about their systems being overwhelmed by applications from people who weren't seen as needing international protection. So in 1992, this led to the London Resolution, a policy that aimed to resist what were viewed as unnecessary asylum applications in order to prioritize those who were genuinely fleeing danger. This resolution laid the groundwork for member states to create their own lists of so-called safe countries where asylum seekers could be sent, and proposed the eventual creation of a common list across the EU. Now, fast forward to today, the concept of safe third countries is firmly embedded in EU asylum law, especially after the adoption of the 2005 Asylum Procedures Directive. But it's important to know that EU law actually outlines 4 different safe country concepts, and these aren't all the same. Let's briefly have a look at each of these. The first concept is safe country of origin. This means that certain countries are considered generally safe for their citizens. Asylum applications from these countries are usually seen as unfounded, and they are examined more quickly to then be rejected. Now, the second concept is safe third country. This is a non-EU country that asylum seekers have passed through where they could and should have applied for protection. This doesn't have anything to do with the details of their asylum claim itself, but focuses on whether they had a connection to the safe country along the journey. Therefore, in this case, the asylum claim is not examined by the country where the person is currently seeking protection, but by the third country they passed through. Now, the third concept is first country of asylum. Here, the idea is that a refugee should be returned to a country where they've already been or could have been, and where their safety wouldn't be at risk. Now, the fourth concept is European safe third country. This applies specifically to certain European countries known for their high standards of human rights and refugee protection. Now let's look at some EU definitions specifically. So, who are these safe countries and how are they decided or defined? Now, given that the EU is one of the most prominent examples of this concept, let's take a closer look at how the EU defines the concept of a safe third country in its legislation. The framework for this is set out in Article 38 of the Recast Asylum Procedures Directive. According to this directive, EU member states can apply the safe third country concept only if certain strict conditions are met. First, Article 38(1) of the directive specifies that a third country can be considered safe if the authorities in the member state are satisfied that the individual seeking international protection will be treated in accordance with the following principles. First, life and liberty are not threatened based on race, religion, nationality, membership of a particular social group, or political opinion. This means that the individual must not face persecution for any of these reasons in the third country. The second point is that there must be no risk of serious harm as defined in the recast Qualification Directive. This includes threats like torture, inhuman or degrading treatment, or the death penalty. The third principle is the principle of non-refoulement, as outlined in the Geneva Refugee Convention. Now, this must be respected. This principle prohibits the return of a person to a country where their life or freedom would be at risk. The fourth principle is that the country must respect the prohibition of removal in violation of the right of freedom from torture or cruel, inhumane, or degrading treatment as defined under international law. And finally, the fifth principle is that the individual must have the possibility to apply for refugee status, and if they are recognized as a refugee, to receive protection according to the Geneva Refugee Convention. This means that for a country to be considered safe, it must guarantee the applicant's basic rights, including protection from persecution and access to refugee status. Moreover, under Article 38(2), the application of the safe third country concept is subject to specific rules established by each member state's national laws. Now, these rules must include, first, a connection between the applicant and the third country. So the authorities must establish that it is reasonable for the asylum seeker to be returned to that particular country based on a significant connection. This could be, for instance, because they previously lived or traveled through that country. Nevertheless, UNHCR emphasizes the importance of a genuine connection through family ties or prior residence, ensuring that it is reasonable for the individual to go back there by considering aspects such as the length and nature of stay. The second point is a methodology for assessing the safety of the third country on a case-by-case basis. This ensures that authorities consider whether the third country is actually safe for the specific individual being returned there. And the third rule is the right to challenge the application of the safe third country concept. The applicant must be able to challenge this decision either by arguing that the third country is not safe for them or by disputing the connection between them and the third country. So, furthermore, Article 38(3) requires that if a decision is made to return someone based on the safe third country concept, the asylum seeker must be informed, and a document must be provided to the authorities of that third country explaining that the individual's asylum application was not examined in detail. If the third country does not allow the asylum seeker to enter its territory, Article 38(4) states that the EU member state must ensure that the person has access to an asylum procedure within the EU in line with the basic principles and guarantees set out in Chapter 2 of the directive. In this line, the Court of Justice of the EU recently ruled that member states cannot reject an asylum application as inadmissible if the applicant is not allowed to enter the territory of the designated safe third country. However, it allowed that a country can still be listed as safe even if it temporarily suspended admissions, as long as there is a legal obligation to accept applicants in the future. Furthermore, it is important to keep in mind that in order for asylum seekers and migrants more generally to be accepted when returned, countries must have a readmission agreement in place. Taking this into account, it could be said that this Article 38 sets common standards throughout the European Union. Nevertheless, national interpretations vary, resulting in political lists of safe countries. This is also why EU law mandates that member states regularly review the human rights situation in any country designated as safe. If the human rights conditions in a country change significantly, member states must reassess whether that country still meets the criteria of being safe. Moreover, safe third countries are not only left to national governments, but national courts also oversee the implementation of these rules, while the Court of Justice of the EU and the European Court of Human Rights reviews these concepts when examining potential human rights violations. However, national procedures and the argumentations behind the selection of safe third countries are rarely made public and often without any civil society consultation. Now, after understanding many of these EU examples, let's look at some non-European Union examples of how safe third countries and the safe third country concept is being used. It is of the utmost importance to remember that the concept of safe third countries is not limited to the European Union. In fact, several countries around the world have adopted similar practices, with Canada, the US, and Australia being key examples. So let's take a closer look at how these countries defined and apply this concept. One of the most well-known examples of safe third country agreements is between Canada and the US. It is the Canada-US Safe Third Country Agreement, which allows both countries to return asylum seekers who enter from the other's territory. Essentially, if a person enters Canada from the US and seeks asylum, they are sent back to the US to have their claim processed, and the same applies vice versa. This agreement is different from the EU Dublin system. While both systems aim to determine which country is responsible for processing the asylum claim, the Canada-US agreement prohibits the application of the safe third country concept to asylum seekers in relation to third countries. This means that if someone is transferred between Canada and the US under this agreement, neither country can send that person to a third country until their asylum status has been determined. Now, let's have a look at Australia. Australia first adopted this practice in 1994, initially targeting specific groups of asylum seekers, such as Sino-Vietnamese refugees. Over time, the legislation expanded, and in 1999, Australia began to apply the safe third country concept even without formal bilateral agreements. This broader application allowed Australia to return asylum seekers to any third country deemed safe as long as that country could provide adequate protection against persecution. The Border Protection Legislation Amendment Act further reinforced Australia's use of the safe third country concept. Critics have noted that this policy shifts the burden of refugee protection onto other countries rather than providing safety and refuge, highlighting the tension between national interests in controlling borders and the international obligations to protect refugees. Now, what is problematic about the safe third country concept? To finalize, let's take a look at 4 of the main criticisms raised by legal scholars, human rights organizations, and international bodies, focusing on the issues like the potential violation of refugee rights, lack of transparency, and the political motivations behind the designation of safe countries. Now, the first criticism is that the safe third country concept is based on the premise that asylum seekers should submit their applications for protection in the first safe country they pass through. Rather than assessing the asylum seekers' unique needs and experiences, the system simply transfers them to a third country deemed safe, where it is assumed that they could have sought or can seek protection. This simplification risks labeling genuine refugees as irregular migrants or economic migrants and leads to their removal without considering their specific protection needs in order to keep asylum seekers out of the asylum system. In other words, failing to take individual circumstances into account can lead to overlooking the situation of members of minority groups who face specific risks of persecution in countries where the majority population is generally safe are often overlooked. So the second criticism has to do with the designation of a safe third country. So it's been mentioned throughout the video already that the criteria for designating a country as safe are often murky, with national procedures varying widely and transparency being a major issue. The lack of openness raises concerns about the political motivations behind the designation of certain countries as safe, which may be driven more by immigration control policies or other geopolitical priorities than a genuine assessment of safety. For example, Bulgaria's decision to designate Armenia and Turkey as safe likely reflects its desire to reduce immigration pressure from neighboring countries rather than an objective evaluation of the conditions in those countries. Another example is represented in the fact that not even within the EU plus countries is there a uniform implementation of the safe third country concept, which leads to legal uncertainties and inconsistencies in how asylum seekers are treated. According to the European Union Agency for Asylum in 2022, in 13% of the EU plus countries, the concept of safe third country is not even defined in national law. In another 13% of EU plus countries, they do not apply the safe third country concept because there is no legal provision for the designation of a national list of safe third countries. Now, in 20% of the EU plus countries, they've not adopted a list of safe third countries, and therefore the safe third country concept is not applied. 10% of the countries apply the safe third country concept on a case-by-case basis because there's no legal provision for a national list, meaning decisions are highly individualized. In 20% of the countries, the safe third country concept is applied on a case-by-case basis, even though the law defines a relevant procedure, but no list has been adopted. Only 20% of EU plus countries apply the safe third country concept on the basis of an adopted list of third countries considered safe. Moreover, the term safe itself can be applied unevenly and politically, depending on national interests. Different countries interpret the concept of safety in inconsistent ways, especially regarding gender-based persecution. For instance, France applies a uniform principle of safety for all genders, while the United Kingdom makes distinctions between men and women for certain countries, such as Gambia and Ghana, where women are considered more vulnerable to persecution. Now, the third argument or criticism has to do with legal constraints of the use of the safe third country concept. So one of the key legal constraints on the use of the safe third country concept is the principle of non-refoulement, which prohibits the return of individuals to countries where they face a real risk of persecution or serious harm. Many states claim that as long as the principle of non-refoulement is respected, removals to third countries are permissible. However, several scholars argue that this interpretation is too narrow and that returning refugees to third countries where they may not receive effective protection poses serious risks. Even though international law allows for the transfer of refugees to third countries under certain conditions like human rights protections, evidence shows that both returning and receiving states often dilute or misuse these protection standards to facilitate transfers, creating loopholes that undermine refugee rights. And finally, the fourth criticism is specifically about a legal basis for safe third countries, or the concept. In the 1951 Geneva Convention relating to the status of refugees, it does not explicitly provide a legal basis for the safe third country concept, and it has been criticized as inconsistent with the Convention's principles. According to some legal scholars, the silence of the Refugee Convention regarding refugees' rights to choose their country of asylum does not mean that states are free to shift protection responsibilities to third countries. Instead, the Convention's object and purpose suggests that states should share protection burdens rather than deflect them. Critics also argue that the use of safe third country rules undermines the principle of burden sharing, which they consider essential to the long-term sustainability of the international protection regime. Moreover, the safe third country concept contradicts Article 31 of the Geneva Convention, which states that refugees should not be penalized for unauthorized entry into a country. By requiring refugees to seek protection in the first country they pass through, the safe third country system essentially punishes those who attempt to move beyond the nearest safe place, often resulting in their removal without a thorough examination of their protection claims. Ultimately, the safe third country concept raises significant legal, ethical, and practical concerns. By allowing countries to shift responsibilities for asylum seekers to other states, often without sufficient guarantee of protection, the safe third country system risks undermining the core principles of international refugee protection frameworks. As critics have pointed out, its application can lead to refoulement, violations of refugee rights, and a weakening of the global commitment to burden sharing. These issues are compounded by the lack of transparency and the potential for political motivations to influence which countries are deemed safe, making the system deeply problematic for those seeking international protection. Now, I know there were a lot of details in this video, but I hope that this gives you a much better understanding of the concept of safe countries or safe third countries and how they're applied. If you've had experiences with these, if you have opinions about how this should or should not be applied, please do leave us a message in the comments. And if you haven't done so already, make sure to subscribe to this channel and hit that notification bell so you don't miss any of the videos that we upload on a regular basis on different migration issues. And I definitely hope to see you next time. Bye-bye.